There's been a lot of buzz lately about the administration's plan to more rigorously enforce the requirement that exists in the law that immigrants and visa holders be self-sufficient, be able to support themselves in order to qualify for either an immigrant visa or a non-immigrant visa. Again, it's been characterized as a backdoor way to reduce legal immigration or penalize people for taking food from a food bank or something like that, deporting people for taking services that they need. Is that what the goal is of this proposal that's been talked about, the so-called public charge proposal?
No. The goal is not to reduce immigration or in some diabolical fashion shut the door on people, family-based immigration or anything like that. The goal, now actually read it out, the goal is simply to enforce, a ground of inadmissibility to this country that's been on the books for about 100 years, well, more than 100 years. It's been on the books in one form or another since the 1880s. And this is the provision in question. Let's see. Public charge. This is section 212A4 of the Immigration and Nationality Act. It simply states, an alien who, in the opinion of the consular officer at the time of application for a visa, or in the opinion of the Secretary of Homeland Security at the time of application for admission or adjustment of status, or getting a green card, is likely at any time to become a public charge, is inadmissible. Likely at any time. Likely, so it's prospective. You're looking, is the person who's appearing before me now seeking to adjust status or overseas applying for a visa, is that person likely to become a public charge? And if so, they shouldn't get the green card or they shouldn't get the visa. So, like it or not, that's been on the books since the 1880s. It was one of the three bases upon which people's admission was adjudicated when they showed up at Ellis Island. You basically asked people, you determine if they were going to be a public charge, you determine if they were sick, in some way that would make them excludable, or you determine if they were coming to in violation of the contract labor law to take a prearranged job. Those are the big three. And in one form or another, that language, indeed the term public charge, has been unchanged in all those years. And the little phrase likely to become a public charge has also more or less been unchanged in many, many decades. That's on the books. There has never been, as far as I know, any regulation interpreting that, ever. There was an attempt back in the 90s under the Clinton administration, shortly after the passage of the Welfare Reform Act in 1996, which brought these issues to a head, to put out a regulation that would define that and define what that meant, and it was dropped. And in its place, a memo was issued that kind of, just a very short memo that basically said adjudicators, when looking at this to determine if someone is a public charge, should only consider, I'm just generalizing, should only consider cash benefits, whether they received cash benefits. Everything else is off the table. What we want to do is issue proper regulations, open to full public comment, the full gamut, the full proper regulatory process to, at long last, interpret what that means. Congress passed that, forever ago. It's been sitting on the books. It's hardly ever been enforced. And if the law is to mean anything, and the will of Congress is to mean anything, we should enforce it.